You know, before we started this deep dive, I honestly thought severance was just one thing. You lose your job, you get a check, and that's it.
That's what most people think.
But reading these guides from HTW Law, I see that in Ontario employment law, thinking that way is basically walking right into a trap.
It absolutely is a terminology trap. And employers, well, they often rely on that confusion. People use severance as a catch-all. But legally, there are two completely different buckets of money here.
Right, and that's what we're unpacking, this huge financial gap between the Employment Standards Act, or ESA, and common law.
Huge is the right word.
Because if you don't get the difference, you're not just losing a few dollars. You could be leaving months, literal months of salary on the table.
Exactly. The best way to visualize it is a floor and a ceiling.
Yeah.
The ESA, that's your floor. It's the absolute statutory minimum.
And minimum really feels like the right word for it. The ESA rules are so rigid. It's just a math equation.
It is, but it's a complicated one. See, the ESA actually splits that money into two distinct types, termination pay and severance pay.
Okay, that distinction really tripped me up. Termination pay seems to cover almost anyone who's been employed for 3 months or more.
That's right.
But severance pay, under the ESA at least, isn't for everyone at all.
No, it's surprisingly exclusive. To even trigger that specific ESA severance clause, you generally need to be a long-term employee, like 5 years or more, and work for a company with a massive payroll.
So you could easily get termination pay, but walk away with 0 ESA severance pay.
Very easily.
But the part in these guides that really stood out was the timing. Termination pay has to be paid out fast within 7 days or on the next payday.
That's the rule. But here's the catch. If you do qualify for that extra severance portion, the employer can actually drag that payment out.
How long?
Over 3 years if they get authorization or if you agree to it.
3 years. For the bare minimum payout. Okay, so let's be honest. That whole ESA bucket feels like pocket change compared to the second bucket, common law.
This is where the landscape completely changes. Common law doesn't care about termination versus severance labels. It just lumped all the damages into one concept. Reasonable notice.
And this is where the math equation just gets thrown out the window.
Completely.
Common law looks at the whole person, your age, your position, your salary, even the state of the economy when you were let go.
That is the key. It's not just weeks per year. It's about calculating how difficult it will be for you specifically to find a comparable new job.
The potential dollar difference is just staggering. I was seeing references to awards hitting 24, even 26 months of pay.
That is the ceiling, yes. So, while the ESA might say you're owed 8 weeks, common law could argue you deserve, say, 18 months.
So why doesn't everyone just get the common law amount? I mean, is it just because you have to sue for it?
That's part of it, for sure. Common law claims filed as wrongful or constructive dismissal suits, they take time. You're betting on a bigger payout later versus a smaller, predictable check now.
But that can't be the only thing.
It's not. The single biggest barrier is usually the employment contract you signed on day one.
Ah, the fine print. So if you signed something years ago that explicitly limits you to the ESA minimums...
You've essentially waived your right to that much bigger common law bucket before you were even fired. That is the most common reason people lose out.
Okay, there was one other massive, really moment for me in these documents. The for cause termination.
Ah, yes. The most dangerous assumption in employment law.
Because everyone assumes, I messed up, I got fired for cause, so I get $0. End of story.
But HTW Law points out this really critical nuance. You can be fired for misconduct and still be owed money.
Exactly. The threshold to deny you your basic ESA pay is incredibly high. The law calls it willful misconduct or disobedience.
But isn't proven.
So just, being incompetent or making a mistake isn't enough to lose your ESA money. Not usually, no. You might be bad enough at your job to justify a for-cause firing under common law, but if your actions weren't willful, you're likely still entitled to that basic ESA termination pay. That is a massive distinction. An employer could tell you, you're fired for cause, get out, just hoping you don't know that cause actually means two different things.
And many people just accept it. They walk away with nothing when they were legally entitled to, at the very least, that first bucket of money.
Which really brings us back to the golden rule from all of this. Don't sign the severance package right away.
Never. The moment you sign, you're settling. The default position in Ontario is actually common law. The higher amount, unless a contract says otherwise. Signing too fast means you're waiving that right.
It really makes you wonder then, if the legal definition of misconduct is so different between these two systems, How many people have accepted zero severance because they were told they were fired for cause when legally that company still owed them a check?
It's a question worth asking. A lot, I suspect.